Arratsaldeon guztioi. Eskerrik asko.
Good evening, ladies and gentlemen, and thank you very much for all of you, for coming and being here to listen to us today. I want to welcome you to this venue, to this meeting, where the foundation that I preside has, as you well know, certain objectives to better collaborate and cooperate with stakeholders in society so that we can work towards an independent Euskal Herria. Oh, sorry, I should have said that is 1 for Spanish, 2 for English, and 3 for Basque, those of you who are listening to the simultaneous interpretation. So, as I was saying, I think all of us here agree that in the Basque Country we need full sovereignty, and to do so we need to analyze first the situations in stateless nations and peoples, and also to find viable solutions so that we can go ahead with our right to decide. That's why we have organized a cycle of conferences of self-government to independence, organized by Alkartasuna Foundation. That's why we are here to talk about the right to self-determination for stateless nations and peoples according to democracy on the one hand, and also studying and understanding all the financial aspects to do so. And to make this possible, we have 2 legal experts here with us who have come all the way from Quebec and from Slovenia. We will first listen to Mr. Turp, who was in charge of drafting the constitutional project for Quebec. He is a professor at Montreal University. He is Secretary General of Intellectuals for Sovereignty, the IPSO. He has also been a member of Parliament at the Quebec Assembly and a member of Parliament at the Canadian Federal Parliament. He has been president of the Committee for Bloc Québécois, and as a result of that, he was in charge of intergovernmental affairs and spokesperson for foreign affairs. As a legal expert, he was also asked to help the Catalonian Parliament and to take part in the committee to study the possibility of having a referendum or a consultation process for sovereignty. We will then listen to Anna Stanic, a legal expert who worked at the Ministry for Economic Affairs in Slovenia. She has a long CV. She is an international lawyer. She's a specialist in European Union law. She has a degree in trade law and commerce by the University of Southern Wales in Australia. She has helped also in international controversies. She worked at Cambridge University and specialized in state succession, which was important in helping. In 2001, her PhD was published in the European Journal of International Law. Ms. Stanic will be delivering a presentation then on financial aspects of state successions. After the 2 presentations, we will open up a Q&A session chaired by Joxerramon Bengoetxea, who is sitting with our experts as well up on the stage. He is well known to you all. He has a degree in law at the University of the Basque Country. He is a doctor in law at the University of Edinburgh, and he teaches at the master's course in the University of the Basque Country. So, without further ado, I will now hand the floor to the speakers. I'm sure that both the presentations and the Q&A session will be very interesting to us all. Thank you very much for your attention.
Jean Andreok,
ladies and gentlemen,
dear
colleagues, it is a very happy moment for me to be back here in the Basque Country. I bring greetings from a number of people who know you well from Quebec, and I want to greet you all who fight for freedom in your struggle for freedom.
Et un mot en français pour remercier Lorena pour sa belle invitation à revenir ici au Pays Basque et découvrir une autre belle ville, cette ville d'Iruñea. Je suis très heureux d'être des vôtres ce soir. I've been asked to talk about the right to decide, le droit de décider, el derecho a decidir. How would we say in Basque? Voilà. And I thought it would be interesting for you to hear from the professor of international and constitutional law that I am and have been now for almost 30 years, and who has, like this young Basque woman I met here, interested in the issues of the legality of self-determination and secessionist movements in many countries and many lands, and to share with you also the experience I have had as a politician, as a parliamentarian in both the Parliament of Canada and the Parliament of Quebec, trying to implement the right of self-determination and the right to decide. And it's very timely, this invitation, because in Quebec, even today, this afternoon, there was a motion in our National Assembly where all parties agreed to reiterate the right of self-determination of Quebec, because the government of Canada, again, is trying, like the government in Spain for you and for the Catalonians and for the Galicians and for others, is trying to argue that, no, we do not have a right to decide. Others have a right to decide for us and for our peoples what we should be and what we should do and what kind of political status we should have. So I would like to share this experience with you and talk about the right to decide. And I've proposed you an outline. It's in French, but I'll translate it in English for you. So in a first, or as an introduction, I will give you a few dates important in the history of Quebec and how our history has been in the past 40 years, the history of trying to become a country and trying to exercise our right to decide and our right to self-determination. Then I'll say a few words on the state of international law, because we have a right to self-determination under international law, peoples, all peoples. And I'll talk to you briefly about two treaties, the Charter of the United Nations and the International Covenant on Political and Civil Rights, and the other covenant on economic, social, and cultural rights. Maybe I'll say a little word on the final Helsinki Act, which also is a document that provides for the right of self-determination and is especially applicable in Europe. And I'll say also a word you might know of the very, very important advisory opinion of the International Court of Justice in the Kosovo case. The court said very important things that we should know and learn from as peoples who want to become countries and that might have to become countries after a unilateral declaration of independence. So that will be the first part of my discussion, and then I'll talk to you about the right to decide in Canadian and Quebec law, because there was a very important opinion also in the Supreme Court of Canada in 1998. In English, it's called Le renvoi sur la sécession du Québec. In English is the reference re-secession of Quebec, where 9 judges of the Supreme Court of Canada stated the law that applies in Canada on Constitution. And surprisingly, the court said that we have a right to decide to become independent if we want. But because the court decided that, the government, with its Clarity Act, tried to say, well, it's not that clear, it's not, it has to be more clear than the court has said, so I'll say a word on that. And I'll end by talking about this legislation we adopted in the National Assembly to affirm our right of self-determination. And this is the law that is challenged now in front of courts, and that gave rise to the motion adopted unanimously in our National Assembly this afternoon in Quebec City. And I'll say a few words about us, about les Québécois et les Basques at the end to conclude my statement. So, a brief introduction, some dates. I won't go back to 1608 when Champlain founded Quebec City, which is now the capital, and many things happened. But the sovereigntist, the movement for sovereignty, for independence in Quebec really became very important, very prominent in 1968 with the creation of the Parti Québécois. The Parti Québécois was then, and still is, and it's now governing Quebec. It has a minority government now in Quebec, but it was founded in 1968. It brought together several parties from the right, the left, the center, some movements, together with the objective of making Quebec a country. René Lévesque was the founding father of that party, a very charismatic, a very loved person. He died in 1998, but he won an election, the first election, in 1976. So it took 8 years between the creation of the Parti Québécois and the election of the Parti Québécois. It was surprising, and it was like a very moving moment in the history of Quebec. It happened on November 15th, 1976, and it's in our history a very, very important moment. It was the moment where we elected a government that wanted to make Quebec a country, and we all believed, I was a very young man then myself, when that happened. And it was the beginning. It was the beginning of a process. It has not ended because we're not a country yet, but it's still ongoing. That's why I suggest you be optimistic, because becoming a country is an ongoing process. Il faut persévérer. That's I think, the key message that I think I would like to send to you. And why? In 1980, 4 years after we organized our first referendum, we lost. 40% voted yes, 59% voted no. It was a difficult referendum, and the people on the no side, they made all kinds of threats, economic threats, and it was really very disappointing, but we lost. We lost. That's democracy. We lost. We didn't win. We didn't convince 50% plus one Quebecers. But the government was re-elected afterwards because it was a very good, competent government in the social, cultural, economic sphere. The danger of losing a referendum is that the government of Canada, in that case, because we had been weakened, they patriated the Constitution of Canada without Quebec's consent. It's a terrible moment in a democracy when you make major changes to a constitution and one province, which has 6 million people, 25% of the Canadian population, was told, you don't agree with the changes of the Constitution? Too bad. We agree. The 9 other provinces and the federal government parliament agree. We adopt the Constitution, and even if you're in disagreement, that's just too bad. It's terrible in a democracy that something like that happens. And this Constitution of Canada, the major changes in 1982, have not been accepted by Quebec now. No government in Quebec has accepted the changes that were made because there were changes in the area of education, of culture. Our linguistic law, our Charter of the French language was implicitly amended in its important provisions. This is something that's historically a very sad moment for Quebec, and we still don't accept what happened. There was attempts to bring back Quebec in the constitutional family, but there was the demise of the Meech Lake Accord. That was an attempt to reform the Canadian Constitution to repair this error of 1982. And there was also another attempt, because that didn't work, the Meech Lake Accord. There was a Charlottetown Accord, and there was a referendum also in 1992 where Quebecers and other Canadians, in 2 distinct referendums. That's really interesting. Quebec, the 1980 gain was, even if we lost the referendum, we had held the referendum. We had proven that we had the right to decide. And in 1982, when it came to accepting or not the changes to the Canadian Constitution to bring Quebec back in the Canadian family, we organized our own referendum. And the federal government organized a referendum for the 9 other provinces. So you see, it was a way to prove that we had the right to decide, even if it was to stay in Canada and accept amendments to the Constitution, because we were holding our own referendum according to our own rules. And we in Quebec voted against those changes. We voted against those changes, and it was really interesting because Canada, in Canada generally, they voted against those changes because they thought Quebec was gaining too many powers. It was becoming too autonomous, much too autonomous. And Quebec voted against the accord because it wasn't having enough autonomy. It was not consistent with what it wanted in terms of more autonomy, more powers. So for very different reasons, this referendum was also lost. And that also meant that a year later, the sovereigntist forces became very, very strong. And there was an election in the House of Commons of Canada where 54 members coming from Quebec, there's 75 people that are representing Quebec in the Parliament of Canada out of 308, like in Madrid here for you. Well, there was 54 out of 75 that were for the Bloc Québécois. So that was a lot of members. It's as if the majority of the members coming from the Basque Country would be favoring independence in the Parliament of Spain. That's what happened in 1993. And then that led to another election of the Parti Québécois with M. Parizeau, who was now the leader, who had replaced M. Lévesque. And he said, if you elect me, I organize a referendum 1 year after you elect me. And we want independence. And he was straightforward. This is what I want. This is what you should want too. I'm going to convince you in the next year. And there was a referendum. And unfortunately, we lost. But look, 49.4%, 50.6%. And I was upset. I didn't cry like I did in 1980 when I was a young man, because I knew that next time I would win. Next time we would win. And so it was disappointing, and then we learned afterwards there was all kinds of other cheating and spending more money than allowed. So I could give you more details about that, about all the dirty tricks that were used by the government of Canada to win that referendum. We say today that that referendum was stolen. And if those dirty tricks hadn't been used, we would have won this referendum. So then we come to the things we'll be talking about more. There was another government in 1998 of the Parti Québécois that will lose in 2003. The Parti Québécois wasn't in government from 2003 to 2012. But in the meantime, just like they had patriated the Constitution in Canada without our consent, now their idea of trying to prevent us from becoming a country was to ask the Supreme Court of Canada if we had a right to decide. And they thought the Supreme Court would say, oh, no, 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 they don't have a right to decide. They just asked the court to answer no. Do we have a right of secession under international law? Please say no. Do you have a right of secession under Canadian law? Please say no. And there was another question about the hierarchy, if there was a conflict between international law and constitutional law. And surprisingly, the court said, you have a right to decide if there's a clear expression of the will of Quebec to become a country. You have a right to there's a right to pursue secession. And if you do agree to secession, there's an obligation to negotiate on the part of the other provinces in Canada. I was surprised. As a constitutional lawyer, I never thought the Supreme Court of Canada would say that. You wouldn't think your Spanish tribunal would do that, eh? I don't think it would do that. Or you would be very surprised also if it did that. Well, the government of Canada was also very surprised because the government of Canada wanted no, no, and it's over. You will never be able to become independent because you don't have a right to become independent under international law, constitutional law. But what is interesting, I always repeat this here in Europe, here in the Pays Basque, or in Catalonia, or in Galicia, or in Scotland. The reasoning of the court was based on, there's two very important constitutional principles: the principle of democracy and the principle of federalism. And in a country that has those two principles as constitutional principles, you have to come to the conclusion that if a people in a country wants to become a country, it has a right to decide. That was the reasoning of the Supreme Court of Canada. Well, the government of Canada, as I told you, wasn't very happy with that. And they tried to, and they adopted in 2000 a Clarity Act. It's called La Loi de Clarification, the Clarity Act. And I'll show you an article of that decision, or that piece of legislation, that tends to suggest that there won't be negotiations unless the question is like this. Or there won't be negotiations unless the majority is clear. But the law, the Clarity Act, is unclear on the issue of the majority. It doesn't say 50% plus one. It doesn't say 66. It doesn't say 100%. It says nothing. It wants to make it unclear. So I'll say a bit more on that. And we replied in Quebec with a law, La Loi sur les droits fondamentaux. It has a big, long title. I'll translate it for you later, saying we have the right of self-determination. We decide our future. We adopted in our National Assembly, we affirmed our right. That was a reply to, you can decide. We will decide if we negotiate with you. So that's also something that I find is always important. Self-determination is about saying ourselves that we can decide. Our parliaments, every time we have an occasion in any kind of election or in any kind of statement made by a person's it's always important to repeat, we have a right to decide. It's our right to decide. That makes a difference. That suggests that we are a self and that we want to determine our future ourselves and not let others determine our future. In the past years, there's been a lot of move in party politics. There's some people that left the Parti québécois that created a party called Québec-Solidaire, a much more left-wing party than the Parti québécois. And in 2011, so 2 years ago, there was another party that was created, Option Nationale. People were not too happy with the Parti québécois. You know about that, creating new parties, when you're not happy with the party that you were part of one day, Monsieur le Président. But Québec Solidaire, the last election, had 6% of the votes, Option Nationale 2%, and the Parti québécois 34%. So when you add the votes together, it's like 42% of people voted for parties promoting independence for Quebec. And it led to the election of the Parti québécois in 2012 with a minority of seats in the National Assembly, 59 on 125, but it's still governing Quebec because it hasn't been brought down by the opposition parties. And we were very proud to elect as a prime minister the first woman in the history of Quebec, Pauline Marois. And I'll say a few words after and then at the end about this challenge of the Loi sur les droits fondamentaux and the Henderson case, which was discussed today even in the National Assembly of Quebec. But a few words on international law. Self-determination is, some people say it's even a peremptory norm of international law, jus cogens. It's so important that you have to respect that right. And it started with the Charter of United Nations. You see, Article 1 of the Charter of United Nations says that among the goals of the United Nations is to develop relations or friendly relations on the basis of the right of self-determination of peoples. So in 1945, it started that way. And it became known that self-determination is a very important principle in international law. Then we went further. The international community went further. It adopted in 1966 two important treaties, which was even more explicit. Look at Article 1. It's so important, self-determination. It's Article 1 of this treaty, or these two treaties. Two treaties say the same thing. Tous les peuples, all peoples, not only colonial peoples, not only peoples subjugated, discriminated, all peoples. And what is important is to read, according to this right, they determine freely their political status. Political status. So become independent or become autonomous in the country you are part of. You can, under the right of self-determination, determine your political status. So become independent if that's your wish. And you could also determine freely your economic, social, and cultural development. Those are very important treaties. And I think you can always rely on those treaties. Some people will say, well, it doesn't allow for the right of secessionist self-determination if you're not a colonial people. But I always remind people, go and read this article. What does it say? Tous les peuples, all peoples. So it's important to remind everyone that tous les peuples, and le peuple basque a le droit à disposer lui-même comme le peuple québécois. And a word on the Kosovo case. I'm sure it was discussed here in the Pays Basque when it was adopted. It was, when was it? In 2010. That's not very long ago. Remember your neighbors, it's not too far, Kosovo, from here. They, at one point, decided that they wanted to declare independence. And they did it unilaterally because Serbia said, no way, you can't become independent. You're part of Serbia. And the Constitution doesn't allow you to become a country. Maybe it did, but they changed it so not to allow them. They allowed Montenegro to become a country in doing a referendum, and it did. But Kosovo, no, certainly not Kosovo. It's too important historically and symbolically. So what did the Kosovars do? They declared unilateral independence. So the Serbs were not very happy, and they convinced some people in the General Assembly to vote, to ask the court, International Court of Justice, to give an advisory opinion. And again, surprisingly, it surprised the international lawyer I was, The court said, oh, international law doesn't prohibit unilateral declarations of independence. It doesn't prohibit. It's clear, look at. Au contraire, il ressort clairement de la pratique étatique au cours de cette période que le droit international n'interdisait nullement les déclarations d'indépendance. International law does not prohibit declarations of independence. And it adds at the end, la pratique, the practice of state, doesn't reveal the creation in international law of a rule that prohibits unilateral declarations. It also said something very interesting that you should always say and repeat to the Spanish state, because that's what I do when it comes to Canada. You know, people say, oh, you can't decide on your own become a country because you will put into jeopardy the territorial integrity of Spain. You're not allowed to do that. You can't do that. You're in my country. If you leave, you're putting you're threatening our territorial integrity. Well, the court, in the Kosovo case, what did it say? It said the principle of territorial integrity is limited to the sphere of relations between states. It can't be applied within a state. When a people says it wants to be a country, it's not threatening of the territorial integrity of states. If France, your neighbors, come and say, well, we want the Basque to be a country, you'd like that, eh? No, they won't do that, I don't think. They would be threatening the territorial integrity of Spain. Well, that's what the court says in this case. But what is very important from this case is that, if our friends, the Catalonians, in a few months decide that they want to become a country and they unilaterally declare their independence, well, they can rely on this in saying, it's not prohibited. If you want to do that, if in Quebec we want to do that, we can rely on the advisory opinion of the International Court of Justice. I see time is flying, but I said a few words on the state of Canadian and Quebec law. Let me just very quickly, and we could continue in the question period, to talk about what happened in Quebec. Well, there was this reference on secession, where the court, applying two principles, decided that we had a right to pursue secession. And, le droit de chercher à réaliser la sécession. When I read that, I was really happy to be told by the Supreme Court of Canada that we had a right to pursue secession. That's how it's written in paragraph 92 of this opinion. And that was seen as threatening to Canada. And in Canada, after this reference, 2 years later, La Loi sur la Clarté, the Clarity Act, was adopted. I was in Parliament then, and I was in the opposition. I was asking questions every day to the minister that was presenting and defending this bill. And the bill has 2 or 3 articles that say that the question has to be clear, the majority has to be clear, and we in the House of Commons can decide if it's clear or not. And it said in its last article that you cannot unilaterally secede. So Canada's argument is that, yes, you have a right to pursue secession, but you cannot do it unilaterally. We have to change the Canadian Constitution before it can happen. So, and I'll go in more detail about that because it's very important. And we challenged this bill. In any case, when it was presented in Parliament, 54 or 48 or 49 out of 75 members coming from Quebec voted against this. It has no legitimacy anyway, even if it was adopted. We voted all against, or almost all of us voted. 66% of Quebecers in the House of Commons voted against this. So what was the reply? What was our reply in Quebec? 5 articles. Look, I like this. It's the first chapter of a bill that's called an Act on the Exercise of the Fundamental Rights and the Prerogatives of the People of Quebec and of the State of Quebec. Article 1, Quebec people can, in fact and in law, self-determine itself. And it's the right Does that mean I should stop now? It's a trumpet. It's a nice trumpet. So you can read also like me. We belongs to us universal rights recognized under the principle of self-determination. We have an inalienable right to choose our political regime and our legal status. We determine ourselves, only ourselves, the ways in which we decide the regime we want to live under in our legal status. And what was very important for us, and still is important, Article 4. When the people of Quebec are consulted by a referendum held under our referendum act, it's called la loi sur la consultation populaire. The winning option is the option that obtains the majority of votes that have been cast and are valid, 50% plus one. Because Canada was saying, oh, 51% is not enough. Maybe it's 55, maybe it's 66, who knows? But they don't say what the rule is. We said what the rule is, 50% plus one. And we could talk about that because it's a very important question. So I end, Monsieur le Président, ma chère collègue Anna Stanic, in saying, vive la liberté, vive l'indépendance pour les peuples d'Europe et du monde. Vive le Québec libre. Gora Euskal Dunak, Gora Euskal Herria, Gora Euskal Herria Alkartasuna.
We've just been told that my presentation is meant to be about now we come to business. Okay, well, yes, we're going to talk about money, I guess. And the first thing to say is that Slovenia didn't do the right thing because it didn't pay attention to the money. And I will show you some of the things that happened. You need to, I think, F5. Yeah, okay. So Lorena asked me to talk about financial aspects of state succession and to specifically talk about what happened in the case of Slovenia, and of course I mean the case of Yugoslavia, because the case of succession was dealt with for all the republics, not just for Slovenia. But some of the parts of the negotiations were done by Slovenia directly with the banks and directly with the Paris Club and the London Club. And that is probably one of the key things I will emphasize in this whole process, that actually the first thing that was divided were the debts. And the reason why that was important was that all states, particularly Slovenia, realized that they needed to be recognized in the international community. And they also needed to get access to money as a new state. And in order to be able to get money, you need to settle how you're going to pay the money that is already owed. So hence, the debts were the first thing to be divided. So I'll talk about that. But before I talk about the money, let me put it all in context, because Lorena wanted me also to explain some of the things about the way in which the whole dissolution of Yugoslavia took place. Ethnic tension is wrongly considered as a cause of the breakup of Yugoslavia. The causes were primarily economic and constitutional. Under the 1974 constitution of Yugoslavia, Yugoslavia was highly decentralized, far more than the Spanish state is today. In fact, our constitution at the time, in 1974, clearly accorded the right that Daniel talked about under the ICCPR, the Convention on Political and Civil Rights. It actually referred to that in the Constitution. So there was a right of every people to self-determination, including the right to secession. And Article 1 also emphasized that. So there's quite a big difference between what our Constitution in 1974 said and what your Article 2 of the Spanish Constitution says, which talks about a unitary state. So a very different set of constitutional situation, but yet the Serbian position was that this was not explicit enough. So you can never get it clear. Even these words were not clear, according to them. And the main thing that is very much a similarity, though, between Slovenia then and the Basque country today and Catalonia today is that Slovenia was a net contributor to the budget of the Yugoslavia as a whole. Already by the 1980s, we were in Yugoslavia, we were already in a deep economic crisis. There was rampant inflation, about over 1,000%, and we had a major political crisis at the same time. And what was happening really was a tension between two sets of, or differences of opinion. One was the centralization policy, primarily put forward by the Serbs, and the others who were calling for decentralization and political plurality. And that is really where the tension started. And the calls for calls for independence were not mainstream in Slovenia, not even a year before independence. Okay, so it was very much something that happened very quickly, and in fact, it was something that even the politicians were surprised by. So the politicians in Slovenia, they were running behind the population. The population was way ahead of them in the demands for independence. What really led to the independence, that's not me, becoming mainstream was the actions taken by the Serbian government to abolish the constitutional rights in Serbia of the Kosovars, so of the very Kosovars who then took over 20 years to become independent. And that was really what spurred the Slovenians to realize that if Kosovo was going to be experiencing this fate of diminishing rights under the constitution, that was going to happen to the rest of Yugoslavia. So we adopted an amendment to the constitution of Slovenia to repeat what the Serbs said was not clear under the Yugoslav constitution, to say that we had a right to self-determination. And this is the famous Amendment 10, which was adopted in July of 1989. And so that was about a year and a half before we actually had our referendum. Okay, so I will stop there because I need to now talk about the money, and that is quite a complicated area. And so I will start by first sort of setting out what the international law of financial state succession is, and really to say the first thing there is that there isn't very much law, in the sense that the guiding principles are clear. That is the principle of equity, so there has to be equitable apportionment between the parties. And there are the key rules that are complicated, and why in the case of Yugoslavia it was very important whether Yugoslavia is a case of dissolution or a case of secession. I will emphasize why that is important, because there are certain rules that apply to how you divide certain assets depending whether you have a case of dissolution or you have a case of secession. So I will talk about that a bit more later. So there is a convention out there called the Convention on Succession to State Assets and Debts. However, this convention, meaning a treaty between a multilateral treaty, is a treaty that only very few states have signed, and in fact it hasn't entered into force. It was relevant for the case of Yugoslavia because Yugoslavia had been a signatory, and at the time of the dissolution of the country, the republics agreed to apply the principles. But in the case of Spain, it may not be relevant unless, for example, you or the Catalans or somebody said that they actually were going to sign this convention and therefore force the hand of Spain to say that it has to either say that it doesn't want to accept it, or that's an interesting thing to consider, whether that would be a thing that you would want to sign up to straight away, or to say that that is something that you plan to do. So the key principle of international law, putting aside this convention, is the principle of equitable apportionment. And I will talk a bit more about what that means, because it's actually quite a complicated thing. How do you decide what is equitable? What is the key? What is the criteria that you would use to determine that? And I will talk about that in a moment. I've listed here just briefly what are the various cases of state succession that have happened in the recent history, and I will of course only concentrate on the case of Yugoslavia. So in the case of Yugoslavia, as I said, the issue of state succession was not something that was considered at all as an important part of the analysis or the preparations. It was very much, as you've seen from what I said, it was something that happened very quickly, and the politicians and everybody was not really ready for it. Also, I believe that there is even now a great belief in political solutions and little reliance on the law as something that assists people to decide things. And I think Slovenia, as a small country, vis-a-vis Yugoslavia and in particular Serbia, should have used the international law much more than it did, which is why I was delighted to be able to come here to Iruñea today to talk to you about what are the rules so that maybe you can do things better than we did in Slovenia. So eventually an agreement on succession was signed, but it was signed in 2001. Okay. And independence was gained in 1991, so 10 years after. As you can imagine, most of the money had gone. The Serbian government managed to control the central bank. The central bank, at the time of independence, had $6 billion in cash. Slovenia has never seen a penny of this cash. Okay. What Slovenia has also made a mistake of is never demanding any of that cash. So that is one of the things that upsets me the most about the whole thing, is that most of the money has never been even divided. Yet the debts have been divided very nicely for us. We get a largest share, or proportionately the largest share of it. The one important lesson to learn, I think, is the fact that the dispute resolution mechanism within the agreement basically is non-existent. If the parties don't agree, there is nothing that happens. And in fact, since 2001, when the bare bones of the agreement were agreed, nothing has happened. Nothing has been divided of the assets. As I say, the debts were all divided, and the assets have been undivided. I say, what does that mean? That means that one nation has remained in control of most of the assets and has not had to equitably apportion anything, which is why this is a very bad lesson, well, a lesson to how to avoid things in the future. So what do you divide? What do you divide when states separate? What is very clear is that you divide assets and you divide debts. But which assets and which debts? Well, what you are dividing is state property. So the question is, what is state property and what is state debt? Now, under international law, and if you borrow the principles from the convention, you will see the definition of state property is based on what the local law of the state says. So in the case of Spain, it would be what Spanish law says state property is. Okay. So that's a very important thing, because you all know what that is. You know what the Spanish law says, and so you will be able to look at that. What is typically the key assets that a state has that are relevant? They are governmental buildings, diplomatic and consular properties abroad. They will be gold, foreign exchange, well, probably not much of that left in most of Europe today, but in theory. And one of the things that actually is a surprising proportion of assets is military assets. They, in the case of Yugoslavia, represented 75% of all assets. So 75% is a lot of assets, which have never been divided. They were left in the basket of things to be divided in the agreement in 2001, and so nothing's happened. Okay, if we move and we look at immovable and movable state property. Immovable property is real estate. Okay, so land and buildings. Okay. The rules there, in terms of international law, are the same whether you are a case of dissolution or the case of secession. So it doesn't matter. You don't have to fight over that distinction. The rule is basically a territorial one. So all assets that are located here in Euskal, is that how you say Euskal? Euskal Herria. Euskal Herria. Okay, that would belong to you. That would stay here. But that is a problem for you because actually most of the assets of the state are not located here. They are located in the capital of Spain today. They're in Madrid. So the territorial principle means that they also get to keep everything that's there. But yet you have over time invested in all those assets. So this is where the issue of equitable apportionment is relevant. Because yes, the territorial principle says that it stays where it belongs. But it also means that you should adjust the other parts that you're dividing to compensate for the fact that they will get, on the basis of the territorial principle, most of those immovables. So it's very important that you make a list of what those assets are. You need to value what those assets cost. It's like a balance sheet. You have to prepare this balance sheet. And this is the process that you need to start doing now, because this is the process that is relevant. This is when you know whether you'll be ahead or behind if you declare independence, yeah? Because it might not pay you much, and at least you should know that it's going to cost you more than you think it will cost you. Okay, so in the case of Yugoslavia, that is exactly what happened. The majority of the assets were in Serbia, and they stayed there. No evaluation was undertaken, no equitable compensation. Okay. As I said, military assets were meant to be divided subsequently. Since 2001, there have been 6 meetings that have all been boycotted. There is no progress at all. Okay, so that is assets located here, or in the case of Slovenia, in Slovenia, so located in situ. What happens with assets that are abroad? So what happens with Spanish assets that you were to divide between the two parts, or 3 parts, however many parts you were dividing it between? What happens to those assets? What are those assets? What happens to them? So here, if we have to distinguish between a case of dissolution and a case of secession, or at least that is what the common argument is amongst international lawyers. I would say that it doesn't matter. My view is that in today's world of international law, I think these principles are out of date. And equity as the fundamental principle of division means that I don't believe that it should matter whether you're a case of dissolution or secession. But let's say that the law is not clear and there could be an argument about this. So that means that you need to be aware of the arguments put forward, whether you're going to accept that if you were to become independent, it would be a case of dissolution of Spain as a unitary state, which I think is an argument that can be put forward very strongly. There's no reason why you should immediately agree that it is a case of secession as opposed to dissolution, especially if the European Union was to argue, or Spain was to argue in the European Union, that you had to apply for membership in the European Union. Then I think your argument on dissolution should be a very strong one, and insisting on that as opposed to secession. But let's leave that. That's a separate sort of argument. Okay, the issue here in the case of secession is that there is a distinction drawn, and it says that if you have immovable property abroad and it's a case of secession, it will belong to Spain. Okay, and depending on the law, that may even apply to movable assets. Now, movable property will actually be a very important proportion of the assets that you will be dividing. Assuming there is still some federal reserves or foreign reserves that Spain has, they are probably all abroad, and those you need to decide who gets them. So this is why the argument of dissolution and secession is very important. Okay, in the case of Yugoslavia, the immovable property that was located abroad represented only 1% of the 60 billion that the assets of Yugoslavia were estimated to be on the 31st of December 1990. That was the date that was taken. That was the date that was eventually agreed upon, because that was the only date that was available from the central bank that had a tally of what the assets were then. So that date was taken, but of course by the 31st of December 1990, most of the assets had gone. So those were just on the books. Everything had disappeared to Cyprus. Cyprus is where all the money went, and supposedly Cyprus is where all the money is. I don't know, maybe they've taken it now with the austerity measures. But anyway, a lot of the Yugoslav assets are still in Cyprus, in bank accounts, that nobody knows about at all. Certainly not the Slovenes. They won't know where they are. Now, what happened with the assets that were abroad? A lot of those were embassies and consular missions and so on. The agreement was not reached about them until the agreement on secession, so by 2001. So for that whole 10-year period, they were used by Serbia entirely for themselves. What was agreed in the agreement was that 5 consular missions were going to be given to the other republics. And what was done at that time was an estimation of the value of those consular missions was made. And the IMF key, which I will talk about in a moment, which was a key that was used to divide the debts, was adjusted to the benefit of Bosnia, Macedonia, and Serbia on the basis that population should be given more weight in the key when dividing the assets. And so they got a larger proportion of that. Okay. And what was decided was that the equitable principle would mean that everybody got the actual buildings rather than for the assets to be sold and then the money divided between them. So everybody got an embassy or something in, I think, for example, Bosnia got the embassy in London and so on. Since then, since 2001, the remaining embassies and consular missions around the world have not been divided. Serbia has said that it won't divide the rest until everything else is agreed upon in the package, and so everything stays unresolved. Okay, if we move to movable property, this was actually very, as I said, there was a lot of money. There was about 6 billion in foreign reserves, and there was lots of money in loans. Yugoslavia lent a lot of money to places like Iraq and so on, and the Serbs were very clever, and they actually swapped those loans for oil supplies. So Iraq agreed to do that, and so the 5 billion of loan to the Yugoslavia just went straight into the pockets of Serbia in terms of oil supplies, and the rest of the member states and Slovenia have lost out. There was 1.7 billion of gold and cash that was actually divided in the agreement. The irony of it was that Serbia got a proportion of that 1.7 billion, even though it had kept everything else on top. So they were far better negotiators than the rest, particularly the Slovenes, and I have to say that, sadly, that is the reality of how it all happened. So that's how you divide assets. And as I say, the important thing there to realize is the fact that it may be important whether you're a case of secession or dissolution as to how you divide them. The key question is, and I think this is the most important thing, is how do you apportion? What is the method? What is the criteria? And different criteria have been used over time. International law does not prescribe any criteria. It simply says that it should be equitable. The question is, what is equitable? And different things have been used in the past to say that something is equitable. So in the Czech and the Slovak case, population was used as the basis. And so they used a 2-to-1 principle, and they divided everything on that basis. So they just went straight. What's the number of people in one country? What's the number of people in the other? 2-to-1, that's the model. And they divided assets and liabilities on that basis. Others have argued that it should be an economic argument. And particularly for countries, presumably like for you and for Catalonia, where you have been a net contributor over the years, you will probably want to insist on there being an economic element to the apportionment, in the same way that Slovenia had insisted on that as an important factor. And so if you see the IMF key, which was first used to divide the debts, but was then applied to most things in the Yugoslav case, it was a combination of things, but it was primarily an economic criteria. So it used things like the contribution of Slovenia to the federal budget. It used the proportion of Slovenia in the social product and the export earnings of Yugoslavia as an aspect. And it used then population and territory as the final aspect. So it was a combined criteria key that used a number of criteria in it. In the case of Yugoslavia, as I said before, slightly adjusted keys, more in favor of population as a criteria, was used to divide things like the diplomatic and consular missions that I mentioned before, and also for other things abroad. Okay, if we now move to the debts, and in most countries in the European Union probably today, we were probably dividing the debts. There'd be far more debts than assets probably left to divide. So this is why I say, in some ways, you need to start with the debts and see where you get on the debts before you decide what you want to do. What is a definition of a debt? Well, under international law, it just says that it's a financial obligation that, in the case here, it would be Spain, that arise in conformity in international law to another state or an international organization. So at the time, and even today, according to the traditional scholars of international law, they will argue that this is the extent of the principle, and so that it doesn't extend to banks and private institutions, because they are not subjects of international law. And so you could argue that principles of state succession, the laws of international law with respect to state succession, don't apply to commercial debt, and that therefore those are things like acquired rights, which you have to negotiate directly with the banks. And so if we look at examples of state debt that would be particularly relevant in the case of Spain, and that were relevant in the case of Slovenia, there are obviously debts to the IMF, debts to World Bank, debts to other states, and debts to private banks. And private banks, we usually call them the London Club. Debts owed to other states is called the Paris Club. And the reason why we refer to them in this name is because they actually have methods of renegotiation within them. So the Paris Club continuously renegotiates debts on behalf of states. So these are existing mechanisms that are out there. So you wouldn't have to create mechanisms to do this. In the case of Yugoslavia, at the time of division, which was, as I say, this random date that was chosen, the 31st of December 1990, the debts were estimated at 16 billion. So the net assets of Yugoslavia was 60 billion. Okay, so the assets exceeded the debts by far. Okay, and the interesting thing, as I said at the very beginning, is that the first thing to have been divided were the debts. And the debt negotiations were led, first of all, with the commercial banks and with the IMF. And so the IMF key was the first to be agreed, the key for the apportionment of debt to the IMF. And then that applied, the World Bank accepted that key, and the commercial banks accepted that key. So it's very important that this is probably the order in which you approach these negotiations. So equity was seen as the guiding principle to the division of debt. And the other principle that was very important is that a distinction was made between the types of debt. So there was a local debt, so a debt entered into by, I don't know, Navarre or any other Pays Basque would be a local debt, which would be yours. You wouldn't be able to divide that with the rest of Spain. So that would be debt that belonged to you at the date of succession. Even more than that, localized debt, so debt entered that was negotiated by Madrid, but that you were the final beneficiary of because a road was built, I don't know, in Iruñea or somewhere else, that would again be debt belonging to you. It wouldn't be part of the division, it would straight be something that you would have to pay. Okay, so the equitable apportionment would apply to the rest of the debt. So the Spanish debt, the general debt, that can't be sent, doesn't belong to Madrid or anybody else. It is actually the central debt. And I imagine that most of the debt in Spain is that kind of debt. So this, I don't know, but this is the kind of analysis that you would need to make. And that is where, in the case of Slovenia, the IMF key was used, and as I say, it was a combination of various criteria, but primarily economic. Okay, so that's sort of like a whistleblower tour of financial state succession. I hope it was clear. What I would like to sort of finish with is like lessons to Euskal Herria. What are they? So first of all, I would emphasize that issues of financial state succession and also succession to treaties is something that you should consider now. You should consider them at the same time that you're considering potential ideas of calling for a referendum. These are things that need to be analyzed. You need to have experts looking at it. You need to think about these things. And the first steps are to determine what is the value of Spanish assets and debts. What of those assets are here? What of those debts belong to here? And remember, to the extent that you're going to want more assets, you'll probably have to take on more debt, because equity will require there to be, at the end, an equitable equitable outcome. There is no doubt that the immovable and movable state assets that are located here will stay here. There's no doubt about that. There's no international law, and there's no basis on which Spain could argue otherwise. But presumably, most of the assets are not here, and the valuable things are either abroad or in Madrid. So you need to think about the key. You need to think about how you are going to apportion those assets and those debts. And there, the Slovenian case is a good one because it tells you that you can probably agree different keys. Therefore, it means that you need to do a fairly sophisticated analysis of what you want. I think the other lessons to learn from the Slovene case is the one that we didn't do, and that is that we didn't think about negotiating the agreement from the start. And so the agreement came way too late when most of the assets were gone. And the other thing, and this is very important, I think, for any new state, you need to negotiate the terms of accession to international organizations like the UN, but also the IMF, the World Bank, and also to negotiate with the banks about how you will take on your portion of the debt in parallel with the negotiations with Spain. Because you don't want to be in a situation where you end up having to take on more debt because the banks are forcing you to pay more, and you've agreed to an apportionment of assets with Spain that is actually worse for you because you've actually accepted less with Spain. And there I will end my presentation. I hope that was clear. Thank you.
We worked on that.
Bueno, arratsaldeon, eta eskerrik asko bi hizlariei. Uste dut biak oso argi eta garbi hitz egin digutela, bai Turp jaunak, Turp irakasleak batez ere printzipioen mailan zeintzuk diren erabakitzeko eskubidearen atzean dauden bi printzipio nagusiak, eta hoiek berak aurkeztu duen bezala, alde batetik
the right to decide. Professor Turp then made that very clear, because we have the right that has to do with democracy, and then in the case of Canada, federalism as well. In your case, in the case of Quebec, democracy should win. Professor Turp has given us a brilliant presentation telling us about their experiences, how they have come as far as they have got to now. We're very jealous when we think of Quebec. We always think how very fortunate you are in Quebec. And we sometimes think it's terribly unfair that you almost made it in the last referendum, but still, as you said, we should be hopeful and positive, and the next one will be the one. I don't know, in our case, I suppose that we still feel that we're very far away from that, not just geographically speaking, but also because you have covered so much ground. We're very jealous. And then Ms. Stanic, gave us a very good description of what happened with the breakup of the former Yugoslavia, how the succession process went, how negotiations were not done right because some of the conditions were not negotiated properly. She has explained very well how liabilities and assets were not shared out equitably. Only debt was. And as a result of that, Slovenia lost out. So, after listening to our experts, I'm sure that that has made you think about how that affects us here in our situation in the Basque Country. I have a question as people are warming up or to break the ice with a Q&A session. Can I ask Anna? I have a question for you. I wanted to ask you if at the time when the breakup happened, was it really clear what debts the former republic was, and were the Slovenian citizens aware of what had to be shared out, both for debts and assets, and then how are decisions made, who has the magic wand to decide which will be best, what will be best or what won't. I think we have to have very clear in our mind when we talk about international negotiations, for instance. Ms. Stanic was telling us that it's very important for us to negotiate here and now, not just with the Spanish state, but also with international bodies, with international institutions, with people who will give us loans in future if we need them. We need to be credit-worthy. And yet, I just wonder, if you don't know if your independence process is going to go ahead or not, how can you negotiate with anybody? I think in the case of the former Yugoslav Republic, maybe that was clearer. In the case of Slovenia, because you were the first state in getting that independence. And I also have a question for Professor Turp. I wanted to ask you about the definition of a people. What is a people? How can we define a people? And does Canada accept that Quebec is a people? That there is such a thing as the Quebecois people? Because you were talking about the Canadian Supreme Court, their advisory opinion. Does the court then recognize that Quebec is a people? And how does the Canadian government feel about that? Are they worried about that? Or are they just worried about the conditions? Or does Canada accept that Quebec is a people? In the UK, for instance, they have no problem acknowledging that there is a Scottish people. Is that something that you debate in Canada, or that's not important and you're just focusing on negotiating the process of self-determination?
I guess when things start having a momentum of their own in terms of independence, you will be surprised how quickly bankers come to knock on your door to find out what will happen to how much, who is going to pay the debt. So actually, in the case of former Yugoslavia, it was very much driven by the banks, who came to ask what was going to happen. And the interesting thing that I didn't mention before is that actually even the Serbs, who were insisting all the time that there was going to be a single state and so on, they were busily buying the Yugoslav debt on the secondary market at a discount. And at several points in time during the whole negotiations, they were trying to actually get paid fully for that debt themselves. So they were sitting on both sides of the division, both as the debtor and as the bank. And so one of the things that Slovenia had to do was to find out which debt was actually already owned by the Serbs, because they would actually be effectively paying the Serbs for that debt. So there were lists and lists that had to be prepared of which banks were excluded, with the help of the United States and other countries which were helping to find this out. So this was a very serious exercise. And of course, one of the things that you can do in preparation yourself is, if you had the money, buy the debt of Spain at a discount now. But that, of course, nobody has that money now to do that. But so that would be advice if you have some rich people who want to be very pro-independence. That would be their contribution.
Mr. Moderator, that's a very good question. And it's interesting how the Supreme Court of Canada, in its advisory opinion in 1998, avoided the issue, is there a people of Quebec? They avoided the issue. They said it's a debate. What is a people? We don't really know what a people is. There's all kinds of definition. There's the objective definition, subjective. People can be people sharing the same language, the same culture, the same even religion, or the other definition, more subjective, is people that want to be together, that have a will to be together, although they might be different language, different religions, different cultures. But the Supreme Court avoided that debate, and it said it wouldn't even answer the question. But what's interesting is that when it came to recognizing the right to pursue secession, the right was recognized to Quebec. Quebec. And then the government, in the Clarity Bill, it implicitly or negatively recognized the right of secession of provinces. That's what you have to read into the Clarity Act. You have an obligation. The word that's used in the Clarity Act is not Quebec, although it's an act to implement the reference on Quebec secession. Then to make sure that it wouldn't only apply to Quebec in case, who knows, Alberta or British Columbia or Prince Edward Island decided that they wanted to become also countries, that it would also apply to them, those rules on clarity. But in the challenge of Bill 9, the act that I mentioned at the end there, the Loi sur les droits fondamentaux, you see what we said in the National Assembly. We said we are a people. The Quebec people is a people, and we have a self-determination. And that's what a people is all about. That we self-define ourselves as peoples. And we try, I guess, at one point to convince people that they're among the people, whether, even if they come and they immigrate to Quebec or to Slovenia or to Scotland or here in the Pays Basque, you come and you become part of a people. And I guess the better definition is a people is where there's a common will to be together. Renan, the great French philosopher, made this really great definition. Une nation, he was talking about a nation, is un plébiscite de tous les jours. It's a daily plebiscite. And I guess that's true for you, the Basque. Being a Basque nation is a daily plebiscite. You have to convince yourselves and others that you are a people and you have the right to decide your own future. And if people want to challenge them, challenge you or me or anyone on that, you remind them that you are a people. That's how you become a people.
I think we open the floor. Galderak, mesedez hori ikusten dut bat listo dagoela eta hor beste bat, atzetik beste bat.
Right, I can see that we've got some hands up at the back of the room, one over here. Great. So, as soon as you get the roving mic, you go ahead and ask.
Hola, buenas tardes a todas y a todos. En principio,
Good evening.
quiero felicitar a la
I want to start by thanking the Alkartasuna Foundation for organizing this fantastic conference for us to see these very interesting different points of view. And I have a question for Professor Turp.
Después de oírle varias veces
I've
sobre el derecho
heard you talk a number of times about international law giving peoples the right to decide, and yet you see the Spanish state not moving. They keep saying that only Madrid can decide. Then what can we do about that? How can we turn that over its head? How can we keep pushing with our struggle? What can we do? And also thinking about Catalonia now, I wanted to ask you, who can we go to in the international community so they can help us and lobby the Spanish state so that we can decide?
Would you like? Yes, I think so.
Well, I guess the first answer to your question when you come to what do we do with Madrid? No, you tell Madrid over and over and over again that you have the right to decide, not them. The best thing to do is also convince the people in your institutions, in government and parliament to also put it into law, put it into motions adopted in Parliament, put it in laws that. But I know what problems you went to, and Monsieur Ibarex, they went into in adopting a law that tells that you have the right to decide, and this is how you will do it through a referendum or through something else. Or I guess what the Catalonians have to do now, the challenge that they have to are faced with is because there was an answer a few days ago or a few weeks ago saying, no, you can't organize a referendum, and we won't allow a referendum organized with our consent on the independence of Catalonia. Well, then you decide the issue in an election, because they can't prevent you from making elections. That's democracy. So you make the issue of independence an issue in an election. And if you win the election, if there's a higher number of seats in Parliament with people that promote independence, and a number more than 50% plus one of people that did accept, that voted for those parties, I think you have legitimacy. Who can say you can't go ahead with independence? The Constitution of Spain, which says it's indivisible, or France, indivisible? Well, countries are not undivisible. And the experience of the international community, and I'll come to what can be done internationally, is that there were 58 countries in 1948 are member of the United Nations. There was a few more that had not been admitted yet. How many countries are there today? 195, if you include Kosovo and Palestine, with the 193 United Nations members. Are countries really undivisible? 140 countries have been born since 1945. Countries are not that undivisible. So that's the answer you have to give. And obviously it is difficult to gain the support of other countries who see themselves threatened by other secessionist movements in their own country. So if you want to go and say, and ask France to accept that the Basque country should be independent, you might have a problem. Well, we had the support of the Général de Gaulle in 1967. If people don't know that episode in our history, the Général de Gaulle in 1967, in a balcony in Montreal, he said, "Vive le Québec libre." You imagine if François Hollande would come here in the Bilbao and would say, "Vive le Pays Basque libre." Well, you know, we like what the Général de Gaulle did in 1967, and we remind ourselves that it's not always impossible that some leaders of countries do something like that. But it's...
He didn't say the same thing in Algeria.
No, in Algeria, you see how incoherent they can be, those leaders. And with what they do with the Basque and French and the Breton and the Corse and everyone, it's quite they come and say "Vive le Québec libre," but they don't even want the Corse to call themselves a people. And that was the Constitutional Council said in France a few years ago. The Corse cannot even say they're a people. It can be written in the laws of France. So I guess when it comes to the support of the international sphere, the idea is to maybe get some supports in parliaments, members of parliaments, and do some lobbying, work in some countries, work with people in Slovenia that know that what it is to become independent, work with Quebec, with Scotland. Maybe I always thought we should create like a G5, 6, or 7, you know, our own G7. Why don't we get together, the Basques, the Catalonians, the Galicians, the Scots, and we create our own G7 and our own G8. And we recognize each other as wanting to become independent and tell others that they should accept that we become independent when we decide freely to become independent.
Arratsaldeon. Arratsaldeon. Fui abogado hasta
Good evening.
el año pasado. Ahora le quiero pedirle
I wanted to ask Anna to explain something that I never understood at university, because equity, I was told, was law plus other virtues. And all by myself, I decided that international law is just a collection of fuzzy principles that don't often help. And I have a question for Professor Turp, for Daniel. Canada signed the Montevideo Convention in 1933. And how can they be so stupid when it comes to Quebec then?
Canadá, bueno.
Do you want to deal with that? And I'll deal with it.
Yeah. I don't think Canada signed the Montevideo Convention of 1933, but I think it's customary international law which says that a country is a country if it has a territory, a population, a government, and has the capacity to have international relations with other countries. But you see, to answer your question, is to show, or to give an answer to it, I would say this. I would say countries that are not truly democratic, they always find a good reason or ways to prevent you to become free. Peoples within. They forget that they became free themselves, that they became independent. Canada became independent from Britain. It was very slow, it was very progressive. The Supreme Court said it happened between 1919 and 1931. And that's why we should always remind the people that don't want others to be independent, that one day they became independent. They self-determined themselves. And they didn't want anyone else to tell them they could, or they couldn't. So, and you know, why are you, probably me, you or your father then in 1980, why do we want independence? We want independence for cultural reasons, maybe some economic reasons, for our identity purposes. We are who we are proud of who we are, we want to talk in our own name, and it's when this identity is thwarted that people want independence. If it's respected, maybe we'll be happy with autonomy. Maybe we'll be happy with the powers we have. Maybe we won't want more because we have enough. There's some countries that work well. Switzerland, the Jura maybe, and there's other countries where there's no secessionist movements, or secessionist movements have decided not to be secessionist movements. That's always why I don't understand countries who just don't accept that people want their own identity and they want more autonomy, and they think in saying no more or be Canadian. You shouldn't be a Quebecer. You should be more Canadian than Québécois. What's the answer? The answer is no. Je suis Québécois et je veux un pays. That's what I guess you also say. Je suis basque. Je veux mon propre pays.
I'll just echo what Daniel says, and I think we are today in a time where actually I think we are now in a place much clearer for the purposes of rights of peoples than we were in '91 when Slovenia became independent. And I think in the European Union we are in a place where the rights of peoples, certainly to hold a referendum, should not be in any question. And I think when somebody else asked what should we be doing, I think the question should be put to the European Union. On what basis can it allow a member state to deny a people the right to hold a referendum when a referendum is an expression of a democratic right? So I think that is the question that should be put loud and clear. It should be put loud and clear by your parliamentarians in the European Parliament. I think it should be put loud and clear by anybody. How is it that a European Union that wants to become some sort of a federal state in which the rights effectively would need to trickle down all the way to here, how can it deny the right to hold a referendum? I think if that was put clear to the Commission and to the Parliament, they could not possibly stand on the side of Spain. I think the question needs to be asked, and it needs to be asked very clearly. And I think you have the right to ask that question. But in terms of equity, yes, it is a nebulous concept. The key thing I would just say is that equity as a concept of law is different to ex aqua et bono. So the one thing that I would emphasize is that as first point. Secondly, yes, it is nebulous, but that means that you can use it to your advantage as well if you know what you're asking for, which is why you need to do your homework and do the lists of assets and liabilities and do your calculations so that you know what you're going to argue is an equitable thing and that you can defend your argument. I know from the Scottish position is that there is no doubt in the United Kingdom, which is where I live now, that the UK government is making the list. And there's no doubt that that is what the actual government is doing. The Scottish have a difficult time because they don't have access to the information. And presumably you would be in a similar situation. And it is that unequalness of position that needs to be addressed. And that's the key.
Can I add something on like that? When we held a referendum in 1995, we were elected on 30th of October, and on the 12th of September, there was the election, we were elected, and the Prime Minister then, Jacques Parizeau, he decided right away, he created even, it was called a Ministère de la Restructuration. And then there was these think tanks working on issues of succession, the best economists, the government employed the best economists, and I worked on one of the committees on military assets. They wanted an international lawyer. And it was so fascinating. I worked with all these soldiers and all these people that were buying these CF-18s, and they knew how much a big, huge submarine cost. And we made all these calculations and how much we would need to pay if we wanted this. And what we didn't want So we wouldn't have to pay. You could keep it. You could keep those tanks. We don't want any tanks. We want to work with the peacekeeping missions of the UN. We don't want your tanks. We want maybe hospitals and things like that. But what I would suggest also is that we even waited too long. It was only in government when we started to do the serious work. Political parties should do that before. The fondation, maybe, Monsieur le Président, votre fondation should already now find the intellectuals, the economists, the lawyers that will work bénévolement, you know, because they believe in the Pays Basque and they want the Pays Basque to be a country. So to avoid taking too much time, or to avoid what happened in Slovenia, taking even a lot of time after independence. So maybe Bildu could bring together the best minds. And I think it is an important issue. You also have to convince some people that you're ready economically to face independence. People need to be secure about what will happen, to know what the assets. And there's more information than you think there is out there. And people know where it is. And there's statistics of international organizations that you can have access to. So maybe that's a nice project for la Fondation.
Two further questions we can take over there at the back. Thank you very much. I want to thank both speakers for their fantastic presentations and thank the organizers for giving us this opportunity to listen to them. Well, I think the topic is quite clear. The issue is quite clear. Civil society nowadays has a right to decide. And in Catalonia, we have found that civil society is self-organizing very well. Then the Catalonian Assembly, Parliament, is pushing parties also to get going. And I think that's news. That's very good news. And talking about state succession, I think the Basque Country is a peculiar situation because we are a state historically that was conquered by both France and Spain back in the 13th century, then the 15th century, going then to the 19th century. Even though Basque society was totally against that occupation or those occupations. So it's not just one state, it's a number of states. It would be really a situation of dissolution or secession. Not really, sorry, it wouldn't be those cases. It would be more like unconquering. There was a conquest and we now need to unconquer the territory. I don't know, in the 19th and 20th century, there have been cases of conquering and unconquering. So what is the relationship then between the state that conquered and the state that was unconquered? Well, the state that was conquered should ask for compensation for all the damage that was caused and made in the territory, the suffering of the population. I'm not joking, I'm saying something very seriously, and it's very timely because Spain and France has a treaty on the border, the separation between those two states. And Article number 1 says that back in 1856, that is 15 years later, after the Spanish border went from the Ebro River to the Pyrenees, covering then the Basque Country. Anyway, in 1856, they say in that treaty, they said that they have taken into account the situation before the two Navarres was divided. So can you ask your question now? Well, here comes my question for both speakers, or maybe Ramon wants to tell me something as well. The question is, would you take into account, could we have that possibility? One state that conquered and one that was conquered?
The only case that possibly could be analogous to what you've mentioned is obviously the situation of the Baltic states and what happened to them when the dissolution of the USSR, and they were not treated as part of the dissolution. They were treated as states that became states again, so they were reconstituted as states. I'm not sure that how far you could push that analogy in the sense of the little facts that I've been told now from you, which I don't know enough about, but the key thing for the Baltic states and why they were able to do that, and they were therefore not required to pay any of the debts, the whole arrangements was a completely different, there were clean slate principle applied to them, was that there were a number of states around the world that never recognized their occupation by the USSR. So they were able to maintain the argument of continuity for the time period that they were under Soviet occupation. So I don't know whether you would be able to make the same argument, and the time is against you because you have many centuries in between. They got rid of the Russians a bit faster than you have. So that's probably the closest that I can think of a parallel in international law. That is not to say that you can't put these arguments forward, and that these arguments wouldn't be arguments that I would use as part of the argument of why dissolution would be relevant. The arguments that you raise in terms of damages would be separately dealt with in any event, in the sense that the division of assets, financial assets, would be divided between the state assets and state debt. Cases of damage, particularly, for example, if the Bosnian wanted to claim damages for the war, those are treated separately. So those claims had to be brought separately from the division of states and assets. So by all means, you can raise this issue in the succession argument to help your claim to say that you're a case of dissolution rather than secession. But any other claims that you would want to make, they would be made separately under separate rules of international law. I hope that sort of makes sense.
I have another parallel. It's not exactly on secession or dissolution. It's on nationalization. I don't know if you remember that Mr. Allende in Chile, when he, in 1971, I think, when he nationalized the assets of several companies, American companies, he said, not only do we not owe any money to these companies, they owe us money because they came and took all our minerals and they exploited us and there's nothing left. So when it comes to compensation, we don't owe anything, they owe us money. But what happened to Monsieur Allende? So you can't say that. You have a position, a historical position of what you've been deprived of, but it's very dangerous. I think what you need, like maybe what Slovenia needed at that time, or any country that wants to become a country, is tough negotiators. Negotiators that say things like that around the table, who remind Spain what happened in all those years. And then, okay, now we can discuss numbers. And then you say 18%. You start at the lowest. That's what we did. In Quebec, we said, we have 24% of the population, we have 20% of the GDP, but you know, you also did things that were not very good and consistent, and when there was a fusion, there was a between lower and high and lower and le Haut Canada and Bas Canada, and we had no debts, and Ontario had all these debts, and so you have to take that into account. So then we come and say it's 18%. They didn't like that. They said it's 33%. So at that point, without negotiations, but people were saying maybe it's 21, maybe it's the population, maybe. So the idea is that maybe you should be a negotiator, a tough negotiator.
Ok, Okay, tenemos dos preguntas más, presidente.
Right, 2 more questions, one of them from our president. Well, it's not a question as a president, but just as a citizen. I have a question for Anna, and then a question for Monsieur Turp, for the professor. Anna, you were telling us about the Slovenian case, and I think the situation in the Basque Country just now might be different because Euskal Herria, the Basque Country, has 3 different administrative areas. We have the autonomous Basque Country, we have Navarre, and then we have the French Basque Country. So the 2 Basque countries that belong to the Spanish state have a lot of autonomy. We can even issue our own debt, imagine. So in the case of Slovenia, the valuation of assets and liabilities compared to the central administration compared to the people who has gone to for secession. Here in Navarre, we don't really care about assets down south in Spain and swapping this for that. I don't think that's going to make that much of a difference for us. And if we had something to pay at the end of that Excel sheet, well, I think that it would be worth it if we get our independence. But my question is different, Anna. In the Basque country here, there are companies that pay far too many taxes. For instance, I'm thinking here about BBVA, a bank, Iberdrola, an electrical supplier, and Petronor, the oil company. Or in Navarre here we have Volkswagen in automotion, and we have Opus Dei with their university and hospital. So I wanted to ask you, in Slovenia, where you had companies from the former Yugoslavia that were located in Slovenia, were you not afraid that they would go somewhere else? Because people over here are afraid that Volkswagen will go somewhere else, and we will lose those taxes from corporate taxes. That's my question for Anna. And then my second question, thinking about normal citizens with their savings in banks. In your case, did it matter if it was a Slovenian bank or a Yugoslav bank? Because we, here in Navarre, we have our own savings bank, and then BBVA, a very powerful bank worldwide, I don't know, we are afraid that BBVA, for instance, would not be located in the Basque Country anymore after independence, and that they might fly to Madrid and stop paying taxes here as well. But not only taxes, I'm thinking about normal citizens who are afraid they might lose their savings, or they might lose the taxes from companies that pay taxes with us now. Because and then I have a question for Professor Turp. I know you like a joke, or maybe that's just an impression I get. I think you have a good sense of humor, but I don't know. I suppose you are lucky, and you might allow Canada to let you hold a referendum, but not us here in Spain. After all the conquests of the Spanish state, they went as far as America, the Philippines, and they did us as well. They conquered us too. So, Mr. Turp, Professor Turp, here comes my question. I wanted to ask you,
se declara
Thinking about Canada or about the Basque Country, if there is a unilateral declaration of independence, what would happen if the Canadian government, in your case, or the Madrid government, sends us the army with the tanks to keep us quiet and to stop us holding that referendum?
Okay, well, I'll just answer the part that Daniel, what happens when they send tanks? Well, if you're lucky and you're like Slovenia, they give them only 24 hours worth of petrol and the tanks stop after 24 hours. That's what happened in Slovenia. That's how we got lucky. They didn't actually think that there was going to be any resistance. In fact, there really wasn't any resistance, but in the sense that we didn't have an army, but they underestimated everything, so they lost that threat. But I think the situation is completely different. I can't possibly imagine that it would ever get to that kind of a situation here in Spain at all. I don't think the European Union would allow that to happen. I think that would be effectively the end of the European Union. So I really don't anticipate at all the kind of scenario that you've painted. In terms of how do you reassure all these companies to stay in a free escaleria, well, that's the kind of negotiations you have to have. They are here for a reason, and I see no reason why they would leave. The fact that there would be an independent state of Escaleria, which is part of the European Union, means business as usual. So you can maybe even tell them they'll pay less tax if they stay. I don't know. That is part of the budget estimates that you will need to make. The key thing as to why it is important that you know how much debt you will end up paying at the end of the split with Madrid is very important for you, as it is for the Catalans, as it was for the Slovenes. You are the net contributors to Spain. You are the ones that the banks, the IMF, and everybody's going to come to ask for as much as they can get. Because they will know they can get more from you than they will get from poorer countries, the regions in Spain. So it is important that you know what you're going to ask for, and it is important that you know what your key is going to be, because that's who you're going to be negotiating with. And believe me, they are going to be the first to come. So you will have to reassure them that they need to stay, whether it's BBVA or Volkswagen, but they will also want to know what the deal is. And in order for you to know what deal you're going to offer, you need to make your bookkeeping like any good house woman or man does. So you need to have your house in order so that you have a consistent message that you give always. And that is why the assessment needs to be done sooner rather than later, so that when you approach the companies, when you approach the banks, when you approach the IMF, you have a consistent position, the same that you will have in your negotiations with Spain.
Let me comment on your first question to begin with, and then I'll talk about tanks and about the army. Monsieur Parisot, the Prime Minister of Quebec in 1995, when there was a referendum, when the referendum was held, the one we lost 49%. Monsieur Parisot was a very, and still he's an older man now, but still very active. He's an economist, a renowned economist. He was professor at l'École des Hautes Études Commerciales at our Université de Montréal. And he had, in the months just before the referendum, put together what he called the Plan O. I never knew what the letter O stand for, but the Plan O. He had talked to the main bankers and to one of our very important credit unions, the Mouvement Desjardins, which holds assets as important as banks in Quebec, which I own because it costs $5 to be a member of that credit union. We're very proud of that. But there's a Royal Bank and all these other banks. He had secret negotiations with people he knew, men and women that that were also concerned about their own assets if it was something unstable happening. And he put together this plan, and he had also organized that on the day we would have won the referendum, and the day after there were enough liquidity there, that anyone who would try to destabilize our economy in Quebec couldn't make it happen. What he said, and that's where I want to come to, he said, I should have informed the people of Quebec before the referendum that I had done that, and I didn't. I kept it secret, and I shouldn't have, because I would have reassured people, and I would have told people, you know, don't worry, because a lot of people out there wanted to make it, if it happens, if Quebecers say yes, they're willing to do something to make sure everything goes well. And there was also this idea, there was personalities, the grandes personnalités, who he had convinced, even if they were not in favor of independence, to come the day after and say, okay, it's done, Quebecers voted yes, that's democracy, let's go ahead. I think it's important to do something, but we lost. On tanks, what would I do? I do this. Like a young man in Place Tiananmen, I would say and stay in front of the tanks and try to kill me because I wanted independence for Quebec. And I'm sure many people would do that. Many people would do that. That's what we have to do when we believe in our country and self-determination. We never let that happen. And if they dare do that, we don't let it happen. But I think Quebec will never have to deal with that because even the Americans won't let the Canadians do that, or the French, or other European countries. That would be so undemocratic that it seems to me that you can not even think of that.
Bueno. Una última pregunta.
We will take one last question for Anna Slavic. For Anna Slavic about the situation just before independence was achieved.
Well, I guess the key thing was, if we go back to, I think, my second slide, when I was talking about the fact that we adopted an amendment number 10, which confirmed our right to self-determination, including the right to secession. That amendment was eventually deemed unconstitutional by the Yugoslav Constitutional Court, not surprisingly, or disappointingly for us, but not surprisingly given the set of circumstances. At the same time, a whole load of amendments passed by the Serbs, abolishing the autonomy of Kosovo, abolishing the autonomy of other republics, amending the constitution, amending the overall 1974 constitution, were not deemed to be unconstitutional. So that's why I said at the very beginning, our crisis was a constitutional and an economic crisis. It was the fact that the constitution effectively ceased to exist. And so Yugoslavia was basically an unconstitutional state. The constitution of 74 no longer applied. And the republics that didn't agree to that. So the country actually didn't operate anymore. The Slovenes walked out of the parliament, and it was the end. So for over 4 months, effectively, there was a hiatus. And so why did it all happen so fast? Because the Constitutional Court of Yugoslavia simply wouldn't listen and kept on saying, in a similar way to the old Constitutional Court in 2010, said no, no, and no. And that no didn't match what the population believed. So the thing went at a speed of within... Well, when my father was in charge of organizing the Slovene referendum, and this was the technocratic government, and most of the politicians didn't want to support the referendum because they didn't know which way it would go, and so my father wasn't even given a budget to organize the referendum. Had to secretly organize the referendum by convincing people to agree to get paid later for the jumbo posters and everything else that was organized. So the and he had to assure the person who then became the president of Slovenia that the population was actually going to vote in favor. The politicians did not believe that the people would vote in favor. And so when they voted in favor, at 88%, Slovene politicians are as surprised as everybody else. So that is the case of taking history into your own hands. And in a way, you can't even rely on your own politicians. Is the story? It's the people that make these things, and that is what you say. What Daniel said. It's the people that make it, and that's the people that have the right. That's how it's decided in the end.
Bueno, ez dago galdera gehiagorik.
Right, any further questions or comments from the floor? If that's not the case, then we will listen to a few words from our president with a formal closing of our session. Well, to be honest, I don't want to take up any more of your time. I just want to thank you once again for coming. And I can tell you that we will have a third conference organized by Alkartasuna Foundation to continue to talk about independence. We will have speakers from both Catalonia and Scotland for that one. Thank you very, very much to Anna Stanic and Professor Turp. Thank you very much.
You were splendid, both of you.